Good afternoon, everyone. We welcome you all to today's webinar conducted by onlinetaxupdate.com on topic Advanced Ruling under GST by Faculty Advocate Ms. Amrita Ji. Advocate Amrita Ji is an LLM from National Law University, Delhi. As a working professional, she is expert in drafting replies to show cause notice, department correspondence, giving opinion, filing appeals and writ petition, etc. Apart from working with different CA and law, she is also doing freelance work wherein she is working in different civil laws for various national and international clients, which includes notices and contract drafting, clients' representation, academic assignments, and ghostwriting, etc. She says that any person can reach out to her seeking clarification on doubts or legal work related to litigation and advisory. She will try to assist them with her best of knowledge and benevolence granted by God. Without taking much time, let us start the session. After the end of the session, there will be a question answer session. You all can raise your query and get clarification at that time. Now, I would like to request Ms. Amrita Ji to take over the session. Over to you, Amrita Ji.
Hello. Hello. Am I audible?
Yeah, you're audible.
Good afternoon, everyone. I'm Amrita. I hope I'm audible to you, everyone. If my microphone and camera is working well according to you, just let us know in the chat box. If there are any doubt or any difficulties, then you must let us know, please. Okay. So regarding my topic, as Ganeshan sir has explained, it's regarding advanced ruling. As everybody knows that this procedure is very much and is a good option for as a consultant or and as a taxpayer for for the best of our knowledge to give to the department and get the best possible solution from the department, so it can be taken for sure for the taxpayer, so there will be no difficulty in future. So before starting my session, I have to share my screen for the same. Just a minute. Just a moment. My screen is visible. Please answer.
Yeah, it is visible. Yeah, it is visible now.
Yeah, okay. So before starting my topic, I just want to share one tagline with you. That is, big shot games begin by assessee but last as per the department's verdict. As we all know that this advanced ruling application doesn't require the expertise only, it's required a good amount of fees also, and another requirement of time and patience to get the department analyze our application, then go for personal hearing and order an appeal and etc stuff. So it's not a good option for a small taxpayer person, or who for a MSME or any individual person. It's not a very good option for him, because paying 10,000 fees just for an application cannot be a good criteria for a ordinary person. So only a high profile taxpayer can only use this option. So that's why I use this tagline. So as we all know that this is the very good mechanism to reduce the workload of the department as well as the assessee. But as and this tax sorry this system has been evolved from the IT regime, then it's come to the customs, then as excise and finance, and after introduction of GST, there is no much changes happen in the provision. It's from section 95 to 106. We can check that more or less all the similar provisions are been enumerated in GST regime, same as the Finance Act. Ganesh sir, I'm sliding my slides. So is it visible?
Yeah, it is visible. You're in the fifth page now.
Yeah, okay. To continue the same, I just want to mention that the provisions of the section 95 to 106 are very much simple according to me, and there is no much amendment happened till yet. and so I'm not going much into the detail of the provision. If I'm required to do the same, just let me know in the chat box, and you can raise the hands. Now coming to the main concern, that why we are here, my major concern for you taking this topic is for to checking the maintainability of the advanced ruling application. What the practical difficulty being a consultant everybody is facing, that we go before the department with the advanced ruling application. So before analyzing and giving hearing and analyzing the taxability and giving verdict, the department is supposed to check the maintainability of the application. So they are always focusing on the rejection of the application, so there is no much requirement to go into the detail and give a hard work for this application. So whatever the manner, they always try to reject the application. So by that, every hard work given by the consultant and the taxpayer will go comes to zero, and the fees is non-refundable for sure. So that's why this topic has raised into my mind, that regarding the maintainability of that how a application can be drafted in such a manner, so to the least it should not be rejected. If it is not rejected, so the department is required to give an order. So by that order, we can take benefit. If there is no benefit, we can go for appeal to the least. So I think maintainability is the most important thing in advanced ruling mechanism. So for that, I'm here to explain the main thing regarding the maintainability. Before that, I just want to mention that any advanced ruling application cannot be rejected without giving a proper opportunity to be heard. And the same thing has also been uplifted in a latest High Court Karnataka High Court case law. So it can be checked later on, and if any kind of discussion or any reference of the case law is required, then please let me know later on regarding the maintainability. As I mentioned, that the severity of rejecting and accepting the advanced ruling is regarding the client should not the client's effort and money should not be gone into the trash, and it should be before the department in such a way that the department will not reject our application. So how the department going to reject any application? They are required to just check section 997(2) and check that all the options given in this subsection are fall with the application or not. So if it is falling in this options, so they can be accepted. Otherwise, it will not be accepted. And besides this, the section, there is another option regarding the applicant. Who can be the applicant of the advanced ruling application? We will look after this subsection and this applicant issue in our next coming slides. First of all, as I've said, who is the taxpayer? Who is the applicant? Who applicant can be the advanced ruling applicant? For example, if the recipient of the transaction X is rendering services to Y, so can Y file an advanced ruling, or only X can file the advanced ruling? As per the ARA department, only supplier can file the advanced ruling. So it has explained in so many advanced rulings orders. For example, this Narmada case, and this Suraj Municipal Corporation, and latestly in UP Metro Railway Corporation also. They, in that case, what has happened, that the applicant is not the supplier of the service or the transaction. So that's why the department has rejected the application. In this case, I feel that if the facts drafted in the application should be narrated in such a way, so it cannot be rejected. In my understanding, when they have explained that we are the recipient, by this anybody can reject the application. But if we talk about that we are the recipient and we are going to pay the tax to the supplier, and later on we will avail the ITC. If we question regarding the ITC, so it will be fall under this determine admissibility of ITC of the tax paid deemed to be have been paid or not. Section 97(2) Clause number D. So if it is drafted in such a manner, so the application will not be rejected. So anybody is drafting any kind of ARA application on the behalf of recipient. If they can question the ITC, so it cannot be rejected. So anybody can frame the case application in that manner. So we can go to the further level of getting the advanced ruling application getting analyzed and understanding the taxability of the question transaction. Next is the application made by the third party. As I said, the application can be filed by the supplier only, or the transaction going to be happen, the person is going to registered or not. I am going to undertake a transaction, xyz transaction, and my concern is by this transaction I'm required to pay tax or not, and I'm not a registered person. So after filing an application, after getting order, and if it is required, then I will get registered and pay the taxes. That person can file the ARA application. But if a person is a third party, neither supplier, neither recipient, he is a third party. So third party can file an application as per ARA department? No. They cannot file the application. Same has happened in Spaceland Solutions case and in Vague Industries case. In this scenario, I want to mention that if a person is a third, maybe a third party, but he is representing someone, as this what has happened in Wright's case. The applicant was a project manager consultant responsible for passing the bill after scrutinizing the same. That per Wright's, the applicant is not a supplier, not a recipient. He is just the third party who is representing the supplier before the ARA department, and the department has entertained the application and given the order as per the analysis given by them. Third option is query related to the issues pending before settled issue or any proceedings. So, as the provision has mentioned, it should not be pending before any department. So, for example, for any transaction, the audit memo has been issued, or any summon has been issued, or any investigation, or any kind of investigation proceeding on any raid, or any assessment proceeding has been initiated. So that person cannot use this ARA application for. The same verdict has been passed in New Rajmandir case and Tamil Nadu nurses case. In the similar manner in Madras Tire case. And the next is not Madras Trier case. It is regarding the questions not related to taxability. So as the section 97 subsection 2 has mentioned 5 to 6 clauses, if the question is not fall under to 5 to 6 clauses, so it will not be entertained by the department. The similar case has happened in Madras Tire case, where the department applicant was in doubt regarding the validity of the tax invoice. They have given a outline of the tax invoice, and that they have asked the department that our tax performa is correct or not. Give suggestion on the same, that we are required to give any input or any clause on the tax invoice or not, and everything is okay or not. So the department has mentioned that we are not supposed to analyze your tax invoice format and answer the same. So the application got rejected. So we must understand that we should understand this, the taxability issue should be a question as per sections 1997 2 only. We cannot ask here and there questions. It should be fall with that provisions only. Next issue is the supply already rendered. The transaction has been completed, is finished, is end, and the question has raised in the mind of supplier or recipient, then you have came to the advanced ruling department. So you cannot do the same. The same thing has happened in Navratana shipping case. What has happened? The whole full transaction has been finished, and the applicant has raised the bill to his vendor with the tax of 18%, and the vendor has said that 18% is too high. We will pay you on 5% tax or any number. I don't remember the rate. So that's why the applicant came before the ARA department and raised the same question. But unfortunately, the application got rejected by mentioning that the transaction has been completed by the parties, and we cannot entertain that kind of application. But on the contrary, what has happened, as they have molded the transaction, so they got the benefit of that fact. In another case, in South Indian Federation of Fishermen Societies, the transaction was completed. There is no doubt regarding the same. They say, but they have molded the facts by mentioning that there is a warranty issue. For example, latestly, in a case has happened. Let me check. Huh. Latestly, Parag Industries have raised a issue where the whole transaction has happened. And for example, I have bought a laptop, and I have worked on the laptop, and that laptop has faced some technical glitches. So the laptop was in warranty period, so I got a replacement. For that replacement, I have paid nothing. The transaction value is nil. If the transaction value is nil, so there must be no taxation on the same. The same similar issue has been raised by the South Indian Federation of Fishermen and the Parag Industries case. This case is 2023 only. So in both the cases, the transaction has been completed. The warranty issues has been raised. On that issue, the ARA department has answered the query. So by that, if we explained a case in such a way, so the department will not have any scope to reject our application. We have to frame our case in such a way, so the department has to entertain our application. It should not be rejected. Next is concerned that if the application is be submitted to the inappropriate forum. I'll discuss the case law later on. But for example, I will take a hypothetical example. So if I've made an application, I have submitted the fee, and I have filed advance ruling before the Delhi department, and the Delhi department has said that this is not the appropriate forum. We are rejecting your application. So my whole fact will be the same. I can file the application to some other appropriate forum, but the fees will be forfeited. I have to pay that fees again to the different state. For example, as happened in growth mode consultancy and Rajeshwar Reddy case, the department has said this is not the appropriate forum. The place of supply belongs to the other state, that is Maharashtra, where the IGST has been applicable. So the Hyderabad department, ARA department has said that you are supposed to go before the Maharashtra state, not before the Telangana. So that's why before filing any application, the consultant as well as the taxpayer should be very cautious that before the department where we are filing this application, it should be very much analyzed and very much sure that before on which department and which authority we are filing the application. This should be the very much important concern for the taxpayer as well as the consultant. Hello, am I audible? Hello.
Yeah, you're audible. Yes, you're audible.
Okay. Okay. By that, as I have mentioned, that each and every concern is regarding the maintainability. So by this, I want to close my discussion that nobody is very much eminent for taking the advanced ruling platform benefit, but we can try our level best to get through, at least pressurize, not just to pressurizing is a negative word, just to remove all the aspects from the department to avoid the rejection of the application. By this, come se come, to the least we can mold our department to the least key that it should not be rejected. So rejection is very much, it's a very waste of thing has happened to the several live cases I have explained to you. It's just a waste for the taxpayer as well as the even for the department, they have analyzed and rejected the application. They must be having that the taxpayer is a very foolish person, that the consultant may be a foolish person, and they have rejected the case. Everything got waste, so it should not be waste. So I think every consultant or a counsel should draft a case vigilantly, that it should cover the strict scope of the advanced ruling regime, so it should not be rejected to the least. Lastly, just lastly, I want to end with this quote by praising the Lord, as I've done this for my whole of my life. That's trust the Lord with all my heart, and do not lean on your own understanding. In all your way acknowledge Him, and He will make straight path for you always. Praise the Lord.
So Amrita ji, this is a better clarification that not only the supplier can file the advance ruling, it is
Yes.
also the recipient who can file it. So
Yeah,
that is the best part.
No, they can file if they have molded the fact in such a way that we are also affected party. If we are the affected party, then it can be accepted. If we are not explaining this, how we are affecting with the transaction, that in this app, if we go for the definition, as per the
97.
definition, it is regarding the renderance of the service. Who is the supplier? The supplier,
Okay.
recipient must not be the supplier. The recipient is the receiver of the supply. And even if it is regarding the scope, it talks about the ITC also. By that ITC clause, we can question that being a recipient of the supply, it's affecting my ITC. And if it is affecting my ITC, I am the person who can file the ARA application before the department.
So it is only the input tax credit, or suppose say that supplier is charging at a higher rate of tax, and as a recipient, I am of the opinion that it can come under a lower rate of tax. So whether in that case, as a recipient, I can go for advance ruling?
You can go as by mentioning the same, that for what has happened in that shipment case, the supplier was asking for the 18% tax, and the recipient was saying that you are charging higher. But unfortunately, the application got rejected by the saying by this order that the transaction has been completed. If it is not so, that person can say that if this is not 8, it should not be 18%, it should be 5%, 12%, or whatever manner. And by that rate of the tax, it's affecting my ITC. It will be affect me. I will pay 18%, I will collect 18%. Why I'll do so? It will loss on my pocket only. It's by cash only, no? That's why then only I can take ITC. So it will affect my pocket. So it can be discussed by the department, and they can get an order for the same. ITC question should be the whole criteria if the applicant is the recipient, and if it is a supplier, then there is no doubt. There is no requirement of discussion of ITC.
Okay, so it is the supplier and the recipient. Only these two parties are there who can go for the advance ruling.
No. As a third party can also go. And the rights case I have explained, rights case is that happened that a person is just giving the framework of the transaction. He is just performing the billing transaction. If the person is following the billing transaction, the department has entertained the case. It's last year case in Haryana ARA 2022. It just depend on the thing, how you frame the case and how you convince the department who is the officer before the ARA. That's by that only.
Okay, so this application, the recipient of service becomes a supplier in case of RCM, reverse charge mechanism. So in that case, it is well, right? The recipient
No. Recipient can say it's in RCM. Can you repeat the question, please?
As in RCM cases, the recipient becomes a supplier, deemed supplier.
For sure. Yeah. Obviously.
So that is.
For sure, they can do that for sure.
So the questions for which the advance ruling has to be applied, that should fall under the section 97 subsection 2. So
For sure.
those clauses,
There is A to G sub clauses, so it should be
clauses,
fall under the same. We cannot
and the
ask any random question. As I have mentioned you the example of tax invoice format.
so it is like that. The application. The next question is the application should be drafted in such a way that
Yes.
the person, the officer, should
Should not
feel that
reject.
it is covered under the clause.
Yes,
And
it
that
is
application
very,
should be
very much important. If the fact is not clear, they will not go into the discussion. So, as per my experience and understanding, the whole application have the major portion of the discussion only. The facts will cover 2-3 pages only. The form will cover 2-3 pages. The major concern regarding the discussion, and the discussion will have all the provisions, the case laws, the notifications, the circulars, the clarification, the opter dicta given by the judge in some manner, the interpretation thing, the major thing which any consultant has given his whole and soul, a last breath to for analyzing the transaction will go waste if the facts is not framed well. So it will be waste. The old discussion, the analysis, nobody will read even. Analyzing the same or giving order is not even a question. They will not even read. After checking the fact, they will reject.
So drafting is very important.
Yeah, it is. It is. That's why I'm concerned regarding the maintainability.
Okay. And then this application, this advance ruling is applicable only for two parties, the applicant and the officer who is passing that order.
Yes, it's regarding the renderance of the service. Now, if it is not the correct forum, as I have mentioned you, the transaction is applicable to IGST, and the supplier has filed application before the registered state. I am registered in Maharashtra, for example, and I have filed application before Maharashtra ARA department. And the Maharashtra ARA department has said that you are supposed to go to Telangana or Karnataka. So they can reject the. So I have to check the transaction, the taxability will be questioned or not. Accordingly, we can decide.
Okay. So appropriate forum selection is also important.
It is so much important. First, this taxpayer, the applicant, who is the applicant? It should be concerned. First, applicant. Next thing is section 97, subsection 2, A to G clauses. Everybody should check. Next, the forum. These three things has to be checked in the facts while we are framing the facts. As per the three parameters which I have mentioned, any consultant can frame the fact, and then later on they can discuss and analyze the taxability. That according to us, this question should be answered like this, and correct us if we are wrong. The department will answer accordingly.
Okay. So thank you, Amrita Ji, for such a wonderful session. I hope all attendees have enjoyed the session. Now we are open for question answer session. Those who wish to ask question, please raise your hand, or you can put it in the chat box. Okay, till question comes, I'll have a small question. Whether same application can be filed in two different states. Supply taxpayer is having a supply in Maharashtra as well as in Gujarat. Two states he is having the same kind of a transaction. Whether same type of application can be done in Maharashtra and same can be filed before the Gujarat Advance Ruling Authority also.
There is no such limit in the same, but understand that being an applicant, I am filing the same thing two states, so I am paying two different fees, two different consultant fees also, because the person has to go before the advanced ruling department for the hearing also. So it will be a difficult thing for a taxpayer. If a person is going to do the same, for example, hypothetically, if I'm saying that person is going to do that and they have filed two application before two departments, so it can be anything. So it's a risky thing. What we can do, that we can file application before Hyderabad, for example, and we have explained our case and discussed the case and got the order. And if the order is not good as per our interest, so we can file application to the another state by molding the facts. That we can do, but doing the application, filing the application simultaneously in one go, it's not advisable as per my understanding. And if any issues have happened with the interstate, there is a option of national committee which is not been notified yet, so there is no discussion on the same. As the GST system has not been incorporated yet, this national committee is of ARAs on also not been incorporated yet, so there is no question on the same. As I advise, I think it should be one by one. If the taxpayer and the consultant think it's a good idea, so it can be used step by step, not in one go.
Okay. Looking into the cost part
Yes.
and that the
Cost, effort, everything. If
efforts,
we
everything.
feel that, for example, Delhi ARA can be more convincing, so we can file before the Delhi ARA and we can check this best possible option. And then if we feel that another option is also available and we can knock that door also, so we can go for the same. In one go, it should not be. In second second step and next step, it can be used in the same manner.
Okay. So as I said earlier, that advance ruling is applicable only for a supplier and the recipient, for the applicant and the department officer, but it can be referred by some other taxpayer as a reference. So similar case is there, and advance ruling also of the same case. So as a reference, that that person can rely on that ruling and he can proceed with the transaction.
Yeah, they can rely on that ruling, and it's an exceptional case actually. Normally, it's not happen like this. Except this right case, I have not seen any other case yet. So we can use that case, no doubt, but it's just an exceptional thing which can be used and it can be taken positively by the department, but we cannot be sure on the same. So we
Whether
have to just
department will accept it or not.
Yeah. We have to just frame our case while I'm saying that I am the third party representative of the supplier. While I'm saying the same, I can quote that right case that it has been entertained application in this case. So we request you to entertain our application also. We can say same, we can plead the same in the personal hearing. We can do the same, but it's just a one case. So it can be advisable, but it cannot guarantee anything because it's department thing. So it can be anything. They can say that it's Haryana ARA, so we are not going to take that as we are from Punjab or maybe from Karnataka. They can say that.
So it doesn't bind on anyone. That is why that is
in ARA, nothing is binding. Nothing is binding except on the applicant and the department only. For example, I am the person who got the benefit from XYZ transaction. I got the benefit. You cannot claim the same benefit. You have to file application on the same, framing the fact and using this case. And then only you can claim that benefit. It's not binding on you. It's binding on me. If the order is favorable or not, it's binding on me and the jurisdiction officer who has issued the order. It's not binding on you. In this ARA, it's the basic phenomena of the regime that this order is applicable only on the taxpayer and of the jurisdictional officer, not on the third party or any other taxpayer. It's not. This is beyond the system regime of the ARA provisions.
Okay. Yeah, one of the case law which you referred in the PPT, it says that the transaction had already happened. For example, in another instance where the transaction is going to happen.
No. It's not has been going to happen. The transaction has been completed. I have given you the example of the laptop. I have bought laptop in November, for example, and it's the warranty of 1 year. I have bought the laptop and I'm using that laptop. I have paid the invoice amount and for example, Amazon Amazon has taken that amount from me and done on the compliances. In June, next year's June, I find some technical glitch or some functional issue in my laptop, so I claim warranty, and it's given by the brand on behalf of Amazon also. So I got that warranty claim, and I my laptop got replaced by the brand, for example Chrome or HP, any brand. So my laptop got replaced and I have paid nothing. The pickup person has came and pick up the laptop and given me new laptop. So there is no consideration given by me or by Amazon. So now, what can be the criteria of taxation on the same? If I'm going to ask, if the Amazon or the brand is going to ask such question, the transaction has been completed. So can the department reject? As per the case laws, they will not reject, because there is a warranty issue. The transaction has been completed, but the warranty issue will be raised after the transaction only. Na?
Yes.
How that warranty issue can come before the transaction? It will come only completing, after completing, and even after the interval, after transaction has been completed, or maybe 6 months, 2 months, 3 months, 3 years. It's depend on the warranty period only. So we have to frame in the facts in such a way that it will be fall under this provisions. The department will not reject our application.
Okay.
You want to ask any other question, or want to wait for the chat?
Yeah, we'll wait for the chat. So actually, I was engaging because there is yet to come. The query has yet to come from the chat box.
I'm waiting. No issues. I'm here only.
Yeah, yeah. We'll wait for 1 or 2 minutes for the chat questions. Okay, then we will proceed with the closing remarks. You all also can raise your hand so that I can unmute you, and then you can have direct interaction with the speaker regarding your queries on advanced ruling. Okay, thank you. So I hope we can conclude the session. And if you all have any query now or later, you can mail us to the speaker at email advo.amrita, that is advocate Amrita at gmail.com. So this PPT we will be sharing with you all. That has the contact detail of speaker, which you can approach the speaker for the queries on this session. Okay, so thank you everyone. Thank you Amrita Ji. We shall soon be meeting on the next webinar on interesting topic in GST.